Hey guys, and welcome to the weekly docket. Hey guys, and good morning. We will get right into this. Let's switch over here. Started a little later this morning. I'm not sure that's good, but let's go. All right, so let's talk about Darrell Brooks first and what's going on with his cases, and we'll cover that, and then we're going to get into some other details on him first. So sadly, he'll be kind of first and toward the end as well. All right, so we watched his pretrial conference that came after that insane dude, and it appeared the state offered to drop 2 of the 3 charges, and the 2 charges they offered to drop were the reckless endangerment, basically the shooting charges. I think if he would plead guilty to the felon in possession. It looked like, from what the judge said, they thought they had a deal, and then that didn't happen. And the defense counsel looked like he thought they had a deal too. And he asked the state to keep that offer open until trial. And I know I saw a comment like, how can he do that? You know, and why would the state do that? I really think he was requesting that because he was aggravated that what he thought was a deal had fallen through. That's my impression. You know, he didn't say that out loud. But both sides agreed that his case would stay on for trial on July 10th. The question of whether Brooks has any reason to settle these cases or not, plead these cases out. Yeah, not really, unless he thinks he's going to get out on the parade attack verdict, but I don't think that's going to happen. So it's his choice to play games to some degree if the state continues to move forward, but that's what's going on with the shooting charges. And the Erica Patterson cases, basically for battery and intimidation, and I think there's bail jumping in that too. That is set for a final pretrial conference of July 21st, so after the trial date for his shooting charges, and then an August 14th trial date. So some people have speculated, hey, that's the case he really wants to attend. And of course, that one did get put off after the shooting cases, so that may have been some strategy he's trying to pursue. I wouldn't put anything bad past him. I will applaud the fact that the glasses they gave him apparently has helped his hearing, or the jail and courthouse breakout rooms have better audio than they did over at Judge Darrow's courtroom, because he apparently can hear well again. So he's getting the treatment he needs when he's not being wheeled around. We will leave him alone and head out to Idaho to Bryan Kohberger. Lots of motions and activity going out there. To some degree, the state and the defense teaming up against the media in terms of what they want to broadcast or not broadcast and information flow. So let's go over that a little bit. It's pretty in depth. So the defense and the state, they want to restrict the information flow via, you know, the gag order or non-dissemination order. And they also want to restrict the broadcasting. So the state makes the argument here that, listen, extensive broadcasting and photographing of a proceeding can be a violation of a defendant's due process rights. And courts have held that, depending especially on how the broadcast is done. Like if they're zooming in on the person all the time, and you'll see that when we talk about what the defense has to say. So there's some difference between showing the proceedings generally, and kind of like they did in Depp versus Heard. I think the camera people did a great job there, versus focusing in on the defendant all the time and leading to excess scrutiny of any expression they may make. And that's different than broadcasting the trial. And I think that's going to be an issue here. So they also cite Judge Boyce in the Vallow case for the reasons that he gave to restrict the broadcasting there. That, you know, apparently there was what I just talked about. You know, they're zooming in on her, and if she blinked too fast, that meant something. And if she didn't blink enough, it meant something. And basically it wasn't about the hearing per se, as much as it was about just zeroing in on her and talking about her. So, you know, that can be an issue. They also say, which I think is reasonable, that they have vulnerable witnesses here who could be intimidated, harassed, or harmed in the broadcast of a trial. And given what some people have said about, at least, say, for example, the surviving roommates, you know, that's a fair point. They also make the point that the jurors, unless they're sequestered, they'd have access to this testimony, and so would witnesses. Well, now that's true for any trial. So that's always a concern, but it hasn't stopped other trials from being broadcast. But I think the first one, that, you know, you got some vulnerable witnesses, that's something to think about. That also could be handled. And then also, you know, just focusing on Kohberger all the time, that's also something that the media will respond to. But these are the points that the state is breaking up. The defense, they don't even want hearings to be televised anymore, much less the trial, and much less anybody talking about it. And in part of their brief, you can see some clips here where they say anytime he appears in court, Like that time he came in for like 30 seconds and had a razor cut and stuff. And, oh my God, was he in a fight? Did he try and commit suicide? And they note these things saying that he's got a cold iciness, it's a complete heart of darkness. So they're saying this guy can't win for losing, whether he's innocent or guilty. If he just shows up in court, they don't really talk about what the court appearance was for as much as they want to label him and demonize him. Now, I happen to think he's guilty, so I don't particularly care what happens to him, but I do care about due process, so I hear what their point is. And let me pick one of these out to say again, good morning to everybody. This was a little later start. If you think that's bad or I should go earlier or later, let me know and I can try and schedule it differently. It's weird using a PowerPoint to do this, I have to say. So I can't really read this, but I'm going to tell you by memory. Maybe you can read it better than I can, but they talk at what I just said is the defense is saying that, look, this is a high level of scrutiny. Dissect every gesture, every shift in posture, every flicker of whatever it is they're saying. And, if you're doing those things, you're going to create an issue for the judge who's like, yeah, if the cameras are being used for this purpose to stare at this guy in minutia every moment of the trial rather than show the proceeding, that's not really to the point of broadcasting a trial or hearing. So, yeah, don't get me wrong. I mean, in my opinion, which is not relevant to the trial, I think the state has a strong case as announced, and they have more than that. And this is the guy who did it. That's my opinion. But he's entitled to people that don't have that opinion to show up as his jurors and give him a fair trial. Okay, he'll be presumed innocent in the trial, but right here in this office, I'm not presuming him innocent, and I'm being open about that. But I am saying he deserves a fair trial, even though I'm using this creepy looking picture of him. So the defense wants the gag order to continue, and the state concurs with that. And they make their points about that basically if you let too much adverse information out there, you could end up having to move this. Why should people have to go to the expense of that? You may not even be able to cure it. And I put this quote in here because they talk about, if it's broad or vague or whatever, it's not really. And then they make the comment in there that people with a business in front of the court for this trial, and they include victims' families. Now, the plain language of the gag order, it doesn't include them. It's the lawyers for the people and law enforcement. So they're kind of slipping in something there that isn't in the current order. Sorry about that. I think it was buzzing. Okay, so on the media side, they say that the public has a right to see what's going on in court, and that's certainly true. I mean, court's supposed to be open. Now, open doesn't mean broadcast. You can have reporters there who come out and report, but their point is a good one, which is seeing what happens in court is good for the public to have, some confidence in the court system. It isn't the solution for that, though, because when I was watching the opening statement in this Peterson case down in Florida, I made a mistake of looking at the live comments at Law and Crime, and the people talking about how the judge doesn't know what he's talking about when he's sustaining an objection at the opening statement, and think when the lawyer's clearly arguing and stuff. People watching what they're looking at, they don't necessarily understand what they're looking at. So just watching a broadcast doesn't necessarily result in this trust and confidence that the media says, because sometimes people don't know what they're talking about. So pool footage means less traffic. I thought that was an interesting argument. They're saying, listen, if you don't let us broadcast, everybody who wants to report on this has to send somebody to the courthouse. But if we have pooled footage that we all use, you'll have less people floating around the courthouse. An interesting point. So they say, look at the George Floyd case versus the Lori Vallow. The Lori Vallow case was mired in people not really knowing what happened in it and having to rely on anonymous commenters and reporters who were there. But they did release the audio. If you wanted to listen to it, you could. And I don't know that the George Floyd case was an example of the highest level of, understanding of what could happen in a trial. People watching that, I think for the most part, either thought this guy needs to be found guilty because I think he murdered this guy, or they didn't. And I don't know that watching the trial changed that a lot. But generally, I didn't watch too much of it. So I don't know for sure. And they say it's better, I think a comment on this, better to let the public see directly than rely on the unethical outlets or online commentators. Yeah, okay. And to some degree, that's true. I think, again, people watching opening statements and say hearing a judge sustain an objection against the side they like, they think, well, this judge doesn't know what he's talking about. And that's just not right. So you can watch something and think that the jury is terrible, the judge is terrible, and maybe it's because you don't know what the law is. So while I agree with watching the trials is better, I think, for the trust and confidence of people who matter are people who will make sure that they know what they're talking about before they talk about what they're talking about. So somebody said, well, what do you think they're going to do? Let me go ahead and answer this question. Yes, the judge will have the final say on it. And even the state does say in their brief, this is to the judge's discretion. Okay. Now it could, think about this though. If they don't broadcast it, I think it's basically no issue for appeal. But if they do broadcast it, the defense could create an appeal issue for these reasons that we've talked about, potentially. So you got to weigh it, which is what the judge said when he was going to set these hearings in the first place. And that's when he was scolding media counsel. He was like, there's not just one side to this. We have to weigh it. So here's a prediction that I will delete if I'm wrong, but you will save it and throw it back at me. I say likely that there will be a more detailed and perhaps more clearly written gag order. I certainly hope it's going to be written in a way that no one can claim they're confused by it, because I think it is pretty clear, but people are pretending to be more confused about it than it actually warrants. In some cases, just because they don't want to talk to the media, so they say, hey, I'm covered by this, even though they clearly aren't. But there should be some factual basis and things like that. So you probably know the media submitted a lot of affidavits from reporters saying I couldn't get this information, I couldn't get that because of this gag order. And that's all fair comments because it is being used to block information that it shouldn't be. But on the other hand, the defense is bringing in an expert to say, if you allow full-scale leaks in this case, or that it can't be fixed and move on the internet, everybody would see it. So I get that. So I think there's a good chance, likely I say more than 50%, that they won't broadcast the trial live. The sides are saying, hey, look what the judge did in the Vallow case by, releasing this audio and letting people watch it in an overflow room and let it get reported on. And then they didn't have to worry about the issues inside of the courtroom. Don't you think there's a good chance this judge would do this? Why would he really care to broadcast it in a case like this, a criminal case like this, if it creates a risk? So I'm tilting it that way. I'm tilting it. Idaho doesn't, I think, have a big history of televising these kind of things. And the parties are saying even these hearings right now are too much. They're creating prejudice themselves, much less the trial. So I'm putting that at a toss-up. But you could bet if the judge isn't going to let them broadcast the hearings, they probably won't let them broadcast the trial. But we'll just have to see. I know they're going to be deciding these motions soon, so we'll have to see. And I certainly could be wrong on that. This judge could say, no, the public interest in watching this is great. And he could decide to block, information in the beginning, maybe even not televise the hearings and say, but when it comes to the trial, hey, we're on trial then, so I will allow it to be broadcast. That's certainly possible. But it is up to the judge. So, it's just something he's going to have to decide on. But we'll see. I don't know. Okay. Let's go to this poll vault. Where we did the poll last week, which was, should jurors be able to speak out? I mean, there was a should there, not whether the law can prohibit it or not. And you can see the results up here. It was 85% yes, and 15% saying, hey, hold them to secrecy, kind of like a grand jury situation. So, there is a safety of witness issue, especially if there are a lot of unhinged people out on the planet. And I'm not, sorry to break back into this, I'm not a fan of gag orders, but I'm kind of becoming one because of the way people are behaving in this Kohberger case, not just to him, okay, because I've already said I think he's guilty, but say to the surviving witnesses, just awful things said about them. Anyway, so on the juror speaking out situation, there were comments for and against. The for side is, look, they should have the same rights as anyone else, which I agree with. And I put this up here. They would be the only people subject to sanction for speaking out about a public trial after it's over. How's that fair? I mean, wait 1 year and then the person says, yeah, when I voted guilty, I meant it. And now you're going to go to jail for that. Plus, if you don't let jurors talk, how else would you know about actual juror misconduct? And we'll get into what that means a little bit. So now against it is the incentive to try to sway a juror to speak out after a trial is over. So if you lose, maybe you'd find one juror and, whether it's ethical or unethical in how you do it, you try and convince them to say something that could get this verdict reversed. Well, that's a danger, but for the rules I'm going to show you, you'll see if your idea was to try and sway a juror unethically, you'd still be better to do it before the trial's over. And your best bet to sway a juror is before they have to make the decision. That's what the trial's for, sway them then. But we'll get into a little bit about, how easy is it to say, get a corrupt juror to overturn a verdict. I'm going to tell you, if you want to do that, do it before the verdict. All right, so a juror could get remorse on their own, though, and then try to undo a verdict well after the case is over. Can any case stand if you just let jurors pop up and say something about the verdict that could cause it to be overthrown? And it also helps appeals, people have said, and it kind of this compromise issue of, well, just don't let them talk until the appeal's over. So, and I agree with that. I think I got this point against it. I agree with it if it's a frivolous appeal. You don't want to help frivolous appeals, but what if the person says something that exposes juror misconduct? Then why would you want to keep that secret until an alleged appeal period runs? So also, it's generally the case that, if something corrupt happened in the trial and the defendant didn't have a way to know about it at the time, or maybe evidence comes up that proves they're innocent or whatever, there are certain things, if it's not the defendant's fault, and they find out about it later, not through a lack of diligence, they're going to be able to appeal anyway. Okay, the normal appeal period is for what happened in a trial, not because we hid things until after it was over. So let's take a look here we'll get to the rules here, because I think people think, at least based on how it gets reported in media, that if the juror comes on TV and says something, the verdict's in doubt and a motion will be filed and blah, 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 and all that. So the general rule is evidence is not allowed to impeach a verdict. In other words, to try and get it overturned based on anything in deliberations, the mental process of the jurors, etc. So even like a statement saying the juror disagreed with the law, or even they misunderstood it, or they were confused about evidence objections and what the evidence was for and stuff, it's not going to be allowed to overturn a verdict. And so that covers a lot of ground, right? Now let's look at Idaho, because Idaho is where the Lori Vallow motion for new trial is filed, in part, only in part, based on the juror interview, where the juror said something that about the nature of the evidence that the defense says, see, they thought it was for this, but it was for this other thing. And also maybe they looked at evidence that wasn't in the trial. So let's see, here it comes. So this is the actual Idaho rule. And I'm going to skip to the second paragraph first there, because it makes the first one make more sense. The court may not receive a juror's affidavit or evidence of a juror's statement on these matters. It's pretty categorical, right? So the prohibited stuff is, during an inquiry into the validity of a verdict or indictment, a juror may not testify about any statement made or incident that occurred during the jury's deliberations, the effect of anything on that juror's or another juror's vote, or any juror's mental processes concerning the verdict or indictment. So if you say, oh, I think the jurors, based on what they said, they didn't understand it, that you can't even bring that up like that. That's why I say this Vallow motion is ultra weak. It's a social media splash, but legally, what is it? Now there are exceptions, and see if you agree with these. Extraneous prejudicial information was improperly brought to the jury's attention. So let's say a juror comes out and says, well, we weren't really sure about what we saw in the trial, but, I went online and I found out this dude had done this 8 times before and they didn't tell us, and I let everybody know, and then we decided to go guilty, okay? Maybe you ought to know that. That goes to the heart of a fair trial, right? An outside influence was improperly brought to bear on any juror. For example, if you vote guilty, your family will cease to exist, okay? That could, have an issue with a verdict. It could go in the other direction too, right? The jury determined any issue by resort to chance. So they said, hey, I don't want to be in here all weekend. Let's do this. I'm thinking of a number between 1 to 10, and you guess it. And if you guess it right, you tell us whether to vote guilty, and we all agreed. That kind of chance thing that's not going to stand if that actually happened, and it shouldn't, right? Because they didn't deliberate. A mistake was made in entering the verdict on the verdict form. Now, that's not going to happen very often, obviously, in criminal cases, because the judge looks at it, the clerk's looking at it. Often the defense counsel will poll the jurors. But if there was a serious paperwork error where it was supposed to be a traffic ticket, but they marked a death penalty, you ought to be able to correct that, right? So these are the exceptions, and this is fairly typical for different states, but every state is different. The things that you can use to impeach a jury verdict, and they are very narrow. So let's see. Said that. So in my opinion, like I said, the motions have more social media impact than legal. And I don't think jurors' speech, especially because they might reveal actual misconduct, should be barred just because social media gets in a tizzy over it. And while I respect the point of wait till after appeals because of frivolous appeals, the law is already, they've been dealing with that for a long time. It's not just whether they showed up on social media or not. So that's been there forever. And I think it doesn't help if the person engaged in real misconduct, because you'd still be able to appeal later, and you should be able to if there was real misconduct. And, you know, the motion's just going to get denied anyway. I mean, motion for new trial is pretty standard to make that. I mean, you don't want to be malpracticing and not file a motion like that. So they think of whatever they can think to file it. The judge decides against it, and there you go. And look at this California case where they say the sorts of things I said about how the juror felt or how they understood or misunderstood the instructions or evidence. It's all inadmissible. Not all thoughts by all jurors at all times will be logical or even rational or strictly speaking correct. But such thoughts cannot impeach a verdict. A verdict is not so fragile. And then they're quoting cases saying a jury failed to correctly apply the law, and most suggest a deliberative error in the collective mental process. So that's a pretty high bar if you want a jury verdict overthrown based on something some juror says later on. All right, let's slip back over to our buddy here, Darrell Brooks, and a question that I wasn't originally planning to bring this in here, but it did put it up because it came up in the Scott Peterson case, which is accusers particularly, but witnesses in general, appearing remotely. And here I've got by Zoom. And as I'll make clear, remote testimony does not equal Zoom. There's two different things. So you have a right to confront your accuser, and that's generally meant to be face-to-face. It's for criminal cases by our Constitution, the Sixth Amendment. It's for criminal cases. It's different standards for civil cases. And this right to face your accuser, it kind of goes all the way back to Roman times and probably before. That's as far back as I checked, and you're welcome to check back further if you'd like. But this idea that if you're going to take someone's freedom away or maybe take their life away, that they should be able to face their accuser in a safe space, a court or whatever. But you have that right because the state is trying to put you away. So I got a lot of comments on that, a lot more kind of than I thought in terms of variety. And they kind of range from, well, it can suck, but I get it. And yeah, and at least the judge can limit the cross-examination. And that's true too. You know, the defendant can't just do whatever they want, or the defendant's lawyer for that matter. And as bad as you think Brooks was, and as bad as he was, sometimes lawyers are pretty bad to victims too. Victims shouldn't have to be in a room with an abuser. And I'm sympathetic to that, but I can't go there. You know, I just can't because of the countervailing values, but I get what you're saying. And then Zoom is just as good as live. Stop being old. Now, I'm going to draw a distinction between remote viewing and Zoom because Zoom is not as good as live. And here's where I say not all remote viewing is the same. For example, you can have court controlled. Like, for example, Brooks the other day when he appeared, he wasn't in an apartment somewhere. He was in confinement and using the court's technology or the jail's technology. So you got a controlled space. It's known technology that is repeatable to the court and reliable. I mean, they know how loud the microphone's going to be and that it works and all that stuff. Now, if you have watched the internet at all, you have seen witnesses calling in lots of times in civil cases by consent of the parties. And in this Peterson case, in a criminal case, even by consent of the defendant. That was what I showed the judge, telling him, look, you're waiving your right here. But I have seen these things occur. Janky Wi-Fi, you know, the person starts jerking around and they go to potato resolution. It could just cut out, right? Somebody cuts the internet off. My phone's at 2%. Somebody sent me an example of a defendant who was being some kind of proceeding for abusing a woman, and he was actually in the house with a woman telling the judge he was somewhere else, and the judge said, go outside and film the house number. He said, I can't judge. My phone is at 2%. If I unplug it, it will die. And while he was a liar, phones are often at 2%. That's true. Exhibit viewing. If you watch the Gwyneth Paltrow case where they had that dude the expert call in from ski resort or somewhere where he was, he couldn't get that thing to work, even though it was an expensive hotel. And how do you show the exhibits to the person? So if you have an accuser appearing, how do you show them this thing and have them see the details of it to testify about it? And you're not going to be able to do that. Volume changes, angles are weird. the things looking up at them and a ceiling fan twirling behind them. Who's in the room with them? Somebody coaching them behind them? Why are there naked people in the room passing by? Why are there children screaming or dogs attacking people? Where are your pants? Why did this disconnect? So witness controlled Zoom. I'm just going to, I often like to see the other side of things, but Zoom is not the same as live, particularly for a critical thing like putting somebody in jail, that you come by Zoom while everyone else is in the courtroom, including the defendant. No. Now, controlled space stuff, that's a little different. All right. So in my opinion, nobody's constitutional rights should depend on someone else's Zoom appearance. Keep it real, please. Now, this case is going to the Supreme Court, or the situation is, because during the COVID scenario, courts were more willing to try this and say, well, the Sixth Amendment right to face-to-face confrontation is a fundamental right, but there are also public, every right has a balancing to it. Whether you choose to believe that or not, that is how the Supreme Court works. And so the courts downstream are saying, well, we're going to assess a balance here. So the case is some kind of fraud case, a financial thing, where a dude testified, and the reasons were, he had a heart problem and he was taking care of his mother. And I think this was during the whole COVID situation, and they let him come in and testify remotely. And he was in his lawyer's office, and it wasn't like he was, in his living room or something. But these people were convicted, and they're trying to get the Supreme Court to hear this case to say that there is no Zoom exception to the Constitution. Now, this has been approached before because, years ago, which, I remember this when I used to help with some of these child cases, a child abuse situation, the child might not be willing to speak in front of the person who abused them. And that does kind of assume the abuser situation. But courts would then look at, well, if an expert's telling me that based on prior talking with the child and this, that, or the other, they would then create a situation where they might limit the impact of this. In some cases, they would put a screen up. They would have the child come to court, but they would put a screen up where you couldn't see the defendant, okay? But everyone else could see the child and all that stuff. So and they even let closed circuit television be used where the defendant was not there, but the counsel for both sides went and talked with the child. So there's a child exception. It's fairly narrow, and I think the court has to make findings of fact and stuff like that in the case, and have an expert testify generally about this and stuff. I don't think it can be routine. I haven't looked at it lately, but that's the only exception really there for someone who's available to testify, but is not going to testify in front of the defendant unless the defendant consents. Sometimes you get, this kind of hearsay statement. Somebody said something outside of court. Well, you weren't there to face-to-face accuse them then, so how can you let it be used in court against them? The Sixth Amendment is violated. There's a whole body of law on that, and that came up in the Mark Jensen case about whether it's testimonial or not. And so sometimes, bottom line is, they will let things said out of court if they weren't for the purpose of testifying against the defendant at that point come into court. And as I just said, this whole, COVID scenario is going to come up of whether in a public health safety situation, if the court finds that there's a safety issue, can they then take away the defendant's right to face-to-face confrontation? So we will just have to see what they do on that. I do hope they take it up. I think it's interesting because this is a case where I don't think the ideology of the court will decide it. In other words, if you're, say a liberal member of the court and you are for, the kind of the rights of criminal defendants, then the right to confront somebody face-to-face is pretty important. But there are also conservative judges who think the same thing, the very same thing. So it would be interesting to me to see how they rule on this. And I'm going to hit a comment here. And this is true. They certainly can do that. I can't believe you think a lawyer would ever interpose a question that wasn't in totally good faith or make a statement during opening statement that was argumentative. I mean, in the old days when I was young, I sometimes had things I said on opening statements objected to and sustained because notice it's opening statement, closing argument. You're not supposed to be arguing in your opening statement. You're supposed to give a roadmap, forecast of what the case is about and the evidence that you say will come in. That's the purpose of the opening statements, not to argue. To argue is the closing argument. So sometimes you will see more, if the parties are contentious with each other and somebody's pushing it, you might see more objections sustained during the opening statement than the argument where there's more leeway for what you can say. There's still limits, but it's, you're supposed to be able to get a little bit of Wild West at that point of the case. So we talked about whether there's a Zoom exception to the court, the balance. And it's just my view that Zoom appearances and even in court appearances, if they're in some other location, but particularly if you don't come to the courthouse, it's not formal. What I'm doing right now is not formal. It is not the same as staring at a jury over there, the witness in the box, the judge and stuff like that. The whole thing is a very different experience. I mean, why not have all of it on the Zoom call? And that's kind of how it was on that video. Somebody pointed me to about the guy who was in the same house with the victim, both of them zooming in, and the judge was zooming, and he had 2 cameras on him, and the DA's here and defense attorney there. And people are like, are you talking to me? Was that supposed to be for me? How about how the jury zoom in? Nobody comes to anything. Everybody just gets a PDF of exhibits, and they sit at home in their pajamas, and they just log in when they can, but they have other important things they have to do. So they just cut off, or they don't pay attention because they're looking at their phone or whatever. This stuff doesn't make sense to me. Like, the idea of maximum convenience and least effort is not the poll star for the criminal justice system. Okay. And maybe technology gets there for that, but it just isn't there right now. And there is something to be said for showing up live. Now, that's not to say that I don't respect the situation of a victim having to be in the room with the potential abuser. That person's still presumed innocent at that point, but if they are the person who did it, that could be very tough to do. But rights sometimes invoke tough situations, and I don't think Zoom changes the necessity of this, particularly Zoom type stuff. So that is what I have on all of this. Anybody got any other questions? And as I say, I would appreciate it when this is over, if you want to leave a comment to me to tell me, like, what's a good time to do this? Because I do have some opportunities to do it earlier, or certainly earlier, or later, if that is better. So just got here, and I kind of feel that way too, because I'm just getting this coffee flowing through the circulatory system. All right, well, let's see here. I appreciate everybody coming through, and thanks for voting in the poll. That was very interesting to see. It kind of was almost a clean sweep in that case. The Zoom stuff seemed to spark a lot of different discussion about whether it was antiquated laws or is important to be able to confront somebody face to face. And I think that's a worthy discussion, and I appreciate people weighing in on it. And everybody have a good day and a good weekend. Thanks. Bye.